Thank you. Mr. Dunmoyer.
Thank you, Mr. Chairman, members of the committee. David Dunmoyer with the Texas Public Policy Foundation. I want to start by echoing a lot of the comments that have been given thus far, just thanking this committee, this body, this legislature on making Texas the foremost leader on privacy. I think we're acknowledging two things can be true. One, Texas is the national leader in data privacy standards. And I'm reminded, Chairman, I've heard stories about how we know the Texas law is the model for other states because there was an editing or Scribner's error in the initial draft, and we've seen that exact error refiled in different states. So if that doesn't make it clear other states are looking to Texas, I don't know what does. That being true, it's also true that there's more Texas can do in the age of AI, and knowing with the Texas Public Policy Foundation, staunch supporters of House Bill 4, and to members that worked on it, notably the author, this is a Herculean lift that took 8 years to get across the finish line. And so we're blessed to be able to have the opportunity here today to talk about what more can Texas do to not just be the pinnacle leader in the U.S., but to do what's right, ultimately. So since a lot has been discussed about the philosophical foundry of data, I want to zoom out for a second and get to kind of the broader aperture on who owns our data. And there's really, just to decant it down, 3 buckets of who owns Texans' data. The first are the controllers that we have a relationship with. And so this sits squarely within the 4 corners of House Bill 4. The controllers are the companies that we tend to think of. These are retailers like H-E-B when you're entering into a rewards program, apps, something as obvious as maybe Google Maps to the more benign, what is your Zodiac? All those apps are collecting information on you. Insurers, we heard about this and that relationship that's happening, and then devices. And I want to emphasize on devices because it's not just our phones listening to us and our wearables, the things that we tend to associate with privacy invasive. In our research paper that the foundation published about 4 years ago, when I was doing this research, I was shocked at the level of data collection happening from smart appliances. And I'm not kidding, if you haven't heard the stories about Roombas, Roombas have videos to surveil the carpet that they're vacuuming, but there's also been instances where, on the one hand, it's used to say, hey, this rug is outdated. Let's serve you ads based on the knowledge we have of the aesthetic and chic in your home, to the more nefarious, which is videos recording and capturing a woman getting out of the bathroom who's unclothed that ended up in the hands of a pornographic website. True story. And so the point I'm illustrating here, our fridges, our TVs, our thermostats, our vacuum cleaners. It seems farcical, but it is so entirely true that these are vectors for collecting our most sensitive information. And to what's been said previously, yes, there is a terms of service that we're accepting that, by the way, 94% of Americans do not read, and those 6% are either lying or lawyers. And they don't, that point that was made previously, it is not a binding contract. I'll get more into that later on. So that's bucket 1, the controllers that we took a great stab in the chest at with House Bill 4. Second are data brokers. And data brokers, you've heard the name, the industry, but by design, you don't know the companies. They are these shadowy, illusory organizations that tend to work lockstep with the controllers to gather that information that's generated. They analyze it and organize it and create a highly specified digital dossier. And the issue of data brokers has been going on for decades. And I know my colleague at Texas Appleseed, they'll be talking about this specific vector. When I first learned about this issue, I mean, this dates back to the early 2000s where highest bidder, they can obtain that discrete profile on an individual that they want to stalk, that they want to inflict harm on. And in the early 2000s, for the cost of essentially a fast food meal, a perpetrator was able to obtain the personal information of a victim who was ultimately stalked and killed. And so the data brokers, they operate in the complete gray area of the law. We do have new laws in Texas requiring registration with the Secretary of State website, but their goal and intent is just to sell that information to the highest bidder, irrespective of the direct and irreparable harm that can befall Texans. Now, finally, the bucket that we're all talking about here today, and one that currently Texas law does not fully cover, is the government. So for the state of Texas, that's approximately 150 state agencies, institutions of higher education, 1,000 plus school districts, 254 counties, increasingly the issue of flock, automated license plate readers, smart city data, which is a whole nother subset of surveillance in concert with ALPRs, but really just an Internet of Things in very progressive looking cities. And the list goes on. And I mentioned, so the TDPSA, there were already too many factions working in opposition to this bill to include government. So there is an explicit exemption for state agencies and political subdivisions in Texas for complying with the Texas Data Privacy Security Act. And so acknowledging that's part of the reason why I'm here today, where can we look to expand that so that, again, one of the vectors that can have the most high-level information on Texans currently does not have to comply with this law. But I want to bring it back to buckets 1 and 2. I talked about collectors and data brokers. Yes, there are vectors the government has for directly obtaining personal information on Texans, but they're going fully into contract with these brokers and with these controllers. And we saw it during the pandemic. There were cities that data brokers came to them and they said, hey, we have all the phone geolocation information of your constituency. Wouldn't it be great if we went to a free contract and gave you that information? And this happened in the District of Columbia. The city obtained the whereabouts information of their citizens to use. Their intended goal ultimately was to track where people were going for COVID vaccine passport checkpoints. So my point here, buckets 1 and 2 are horrifying. The third bucket of government not needing to comply with this law, there's a clear workaround there, and I think it demands scrutiny as we look to addressing this issue more holistically next session. So now to answer the question on the charge more directly, who owns Texans data? And as we've heard, statutorily, we don't. Texans do not own their own personal information. Texas has never granted its citizens title to their own data, so ownership ultimately defaults to possession. The companies that collect it treat it as a balance sheet asset, as we've heard about, and I think a story that really firmly illustrates this is when Radio Shack went bankrupt. I believe Texas-based company, when they were going through the bankruptcy process, it tried to sell all the remaining customer files and data files like it was their leftover inventory. And it almost went through were it not for intervention on the part of the Attorney General's office. And I'll echo the points that we have an Attorney General now who is full-throated in ensuring privacy is protected, but we need to think about structure and not just personnel. So for the next 8, 12, 20 years, we have those protections in place. Another point I want to highlight here, just concerning state ownership of data, they own and control data on millions of Texans, and we might think directly Department of Motor Vehicles or some of the health records that are obtained. But just a few months ago, the Texas Parks and Wildlife Department had a data breach that resulted in over 3 million customers' information being completely unsecurely released out to the public. And this was driver's license information, passports, other sensitive personal information. And in those cases, Texans absorb the harm and they don't have any direct recourse. So there's one exception to this rule that I want to talk about, and that's in 2023, the legislature, you all codified that DNA is yours by statute. And so we have this in the Business and Commerce Code in Texas. However, your location, your face, your driving record, your children's data are, legally speaking or statutorily speaking, whoever has them at that time. And that's the gap that I really wanted to highlight here today. Now, finally, TPPF believes that we can and should flip the script on this. If the current regime is I come hat in hand to the tech company asking, please don't collect this information, please allow me to opt out of these discrete categories or delete this information, that's the backwards way of looking at it if we are to see this as our personal information and our property. And so the way to put an end to this, we have all these issues emerging now in 2023. Chairman, I don't think we foresaw what was happening with artificial intelligence fully, and each minute of every day we're seeing new threat vectors emerging. And we can talk about edge cases like Flock, AI data training, cyber hygiene, and we should, and those demand individual scrutiny. But we can fundamentally flip the script by ensuring that this personal information is recognized as the property of Texans. It was about 4 years ago when I first had my foray into data privacy, when a colleague and I authored a research paper on why Texas needs a digital Bill of Rights. And we went through all the different threat vectors with data brokers, the economic and personal harm befalling Texans due to cyber breaches, and ultimately provided some thoughts on digital rights that we now see reflected in House Bill 4. So check, check, check. However, there was one central thesis that a colleague and I kind of just put in as, I'm the only, I think, non-lawyer up here, but I've read Clarence Thomas's footnotes that he leaves as Easter eggs in a lot of his decisions. And so we left a footnote a la Clarence Thomas. And in that we said, quote, the authors of this paper philosophically hold that data is property and ought to be considered the property of the user generating this data. For example, a painter owns their painting, not the canvas manufacturer or art supply store. Data should be treated like the painting. The legislature should codify data as property of the user to acquire, use, and dispose freely of this digital property. We believe this holds even truer today in the age of AI than it did in 2022. So with that, I want to be mindful of time. I know you all have had a very long day here. Just want to say again, thank you for having this hearing, this discussion, and happy to answer any questions you might have on the subject.
Thank you all for your presentation. Representative Tinhold was first.
Thank you, Mr. Chairman. Thank you for being here today. So I'm not a lawyer. If Texas were to change the law on the data privacy, would that or could that negate any prior contract signed, or could verbiage in the legislation change that? Meaning, let's say 2 years ago, 10 years ago, I signed one of those. Mm-hmm. I want to own my own data. Will a law fix that? Or does the law, to make it legal, would verbiage in the law make it legal?
Sure. Do you want to take the first?
Does the question make sense?
No,
Yes,
totally.
I want to
does,
own my
yeah.
own data, and we want to fix things because people are unknowingly signing things because they're not lawyers. But let's just say I've got a refrigerator with a camera in it in the house, and I signed that, and I learn about this. The average citizen's not going to know how to go amend the contract. They're just not going to be able to. What I'm saying is a blanket across the board, because these companies are making millions or hundreds of millions of dollars off the data. I get it. They're going to keep doing that. Of maybe where I shopped and what I did. But when we're talking about videos and we're talking about things in my home, I want people to truly have privacy. The average citizen also can't afford to go get an attorney to change a contract with AT&T. How do we solve this as a legislature? You guys are the experts and you're smart on this stuff. And I want him to be able to go first because he only out of respect because he said he did. How does the legislature fix something like that long term to cover the most contracts where people are getting abused?
Yeah, no, it's a fantastic question. So coming at it from a non-legal perspective, what I would say, and this is the case on a lot of child safety laws that we've worked on, that, like, let's say there's a new statute and requirement on parental consent for downloading apps. And there is no retroactivity put into the actual letter of the law. However, it's based on the assumption that there's a contractor going into that would trigger or activate that new law. Every time an app updates, there's some new iteration to it. You may have seen this when you go, let's say you use Instagram and it says, hey, there's been an update to our privacy services, click accept. That would trigger, and that would be a new contractual obligation that you're entering into each and every time that update is made. So is there a way to do it, to write it retroactively? I do not know. They might have an answer to that, but what I can say is in the tech world, they are required by law for certain cybersecurity updates and certain hygienic standards to make those iterative updates to the app, which triggers on the consumer front. I see, okay, I have to update the app, and then boom, I'm now accepting a new contract. That could be the avenue with which you would apply this new privacy regime were it to pass. If that makes sense?
So you're saying anytime that they upgrade their software, our law would say when you upgrade it and make people click the button, that they're agreeing that they own their own data and that you don't have a choice, that these companies don't have a choice.
Right. If it's written in a manner that requires that compliance, like let's say, for example, the update, here's the contract, and it says, do you elect to maintain total control of your information and not give more than what is necessary to run the service? I would say, yes, I would like to have maximal control over my data, or the alternative of, nope, take all of my data. That's essentially the current regime, finding ways to tweak the law such that, again, it recognizes it as inherently valuable, whether it's a digital dividend, as Joel outlined, or it's something more statutorily.
That makes sense. And we do what you said and allow the Attorney General to go after them for not complying if they take the data and they use it. I mean, you heard earlier, we had $1 billion lawsuit that was won? Which is what the Attorney General would do. Yeah. The Attorney General would hire an attorney, but then the state would get the money. I'm just trying to, as I hear these things, we're always surprised up here, right? Just because we're legislators doesn't mean we know everything about everything. I'm never surprised anymore after 12 years of being here to hear things during these hearings that just totally surprise me. I'm not surprised that data's collected. I get it. But I am surprised at how the data is being used by some of these companies that truly should be my data, right? And did someone say the state owns the data? Is that what you said?
Well, the point I was illustrating is that under the Texas Data Privacy Security Act, it doesn't apply to state agencies or political subdivisions. And this is getting into the issue as well of Flock and automated license plate readers, which is not owned by the private company Flock itself, but that's going to be law enforcement or the HOA that they're going to contract with.
Okay, that makes sense. Thank
Okay.
you, Mr. Chairman.
Thank you, Representative King. Okay, Representative Alders.
Thank you all. This is a fascinating conversation, and I think the founders of our country would be wondering what the heck we're talking about when data look like I'll take a pen name and I'll write a letter, and then someone else will take a pen name and write a letter, and that's data. We've got a different problem on our hands now, and I need some clarification for this conversation, because I'm not a geek. And so I was trying to figure out how to categorize certain kinds of data. Is there a way to draw a line between either the kind of data or users, what data should be considered private versus public? In the context of social media, for instance, which we've been discussing to some degree, is that public or private, or should we have different definitions or restrictions and regulations based on whether it's our data that we're utilizing for Google, Microsoft, Apple on our devices versus what we are willfully putting out in the public sector, and we think we have more protections around that? Should there be a different level of protection based on what kind of data we're talking about? I just throw all that out there and anyone can tackle that.
Well, thank you for the question, Representative Ballers. That's a fantastic question. We were chatting about this beforehand. In the Texas Data Privacy Security Act, there are certain definitions that kind of draw the line on what are duties and responsibilities. One class is sensitive information, which is precise geolocation data, your race, religion. I don't have all the rest of them written down, but what we would tend to associate with the most sensitive, what it could have a legal effect on me and my whereabouts, depending on who obtained that information. Then there's a definition of personally identifying information. And this is where things have changed since the dawn of AI, because PII would be classified as a set of data, and the chairman can answer this better than I can, that can be directly associated with my likeness. And at the time, that was a very concrete, good standard of, okay, let's have that information de-identified such that we might know Representative Alders. We have some data points on what kind of bread you like to buy and what kind of car you like, but we're going to take your name and completely extract it from it. So all the advertiser knows is this is a person who we should serve ads on this kind of bread. With AI, it's now something like 99.99999% of de-identified data can be re-identified. And so the point I'm making, I'm not answering your question directly, is that with the moving goalposts on what data is what, it makes it really hard to say, here's the hardline standard of what should be considered property, as opposed to this is permissive because it's not unnecessarily onerous or invasive. So I think philosophically speaking, anything that kind of back to that sensitive data question that could have a legal effect on me or a substantial effect, define that however the legislature saw fit, that meets that category and criteria. But under the current definition of PII, if it's sold as Representative Alder's information sans his name, and then boom, let's use AI to extract one or two more data points to re-identify it, then it completely nullifies that protection. Does that make sense?
Yeah, that it does help, but that it sounds like more of a privacy answer rather than whether or not we're talking about that data being a property right
Sure.
for the user or consumer. I mean, if I'm deciding to take advantage of all of the luxuries of modern era, and so I'm typing in to Amazon or Walmart or whatever else site the things that I'm looking for, I mean, I'm wondering to what degree I should be saying I have a right to the data or this personality that I've put out there online so that my life is easier. At what point do I get to say, that's me, you don't get to utilize any of that?
Yeah.
And I don't know what that line is. I'm asking the question.
Okay.
I don't think my next question is too novel, but let's say we're talking about a Ring doorbell. Let's pretend the information is property rights. Let's say it's property. And when I consent to them to do it, I guess I've consented for myself. What about my children? I mean, biometric data was maybe one of my bigger concerns, but let's say I permitted you to have my iris scan with my kids when I posted their photo to Facebook or any of the other people, or my spouse. Did she sign the consent to the use of that Ring doorbell? Is this any consideration? I mean, because I could see maybe like I agreed, I signed the consumer agreement, but everybody else affected by it. It seems like there's more than just you being affected by this technology around you, and that if we're doing this reasonable expectation of privacy, sure, man. And I don't know. Me and my wife in the bedroom, we got a reasonable expectation, and my cell phone's somehow listening to us. I don't know. She didn't consent to that, though, right? Or what? I'm kind of curious about how we protect these third parties.
I can take a stab at that initially, because I know tomorrow Pub Health is having a hearing on child online safety. And all this stems back to, on child privacy, 1998, the Children's Online Privacy Protection Act. It says, very simply, that if there's a digital service provider that collects personal information and a child is 13 or younger, that they must have affirmative, verifiable parental consent before using that website. I don't know how many of y'all have kids that have used websites or how many times you've been requested to provide that affirmative consent. Tech companies don't adhere to it because they say, we're setting our terms of service to 13 plus, and so we're assuming as a default that you are in the most privacy permissive regime, and so COPPA need not apply. It's that actual knowledge standard. We don't, I know Joel made this point, these tech companies can quite literally know more than our spouses know about us, but somehow they can't know our age or the age of a child. That terms of service set to 13 plus was the crafty design of them working around that 1998 law. And the Texas Data Privacy Security Act does require COPPA compliance. And this is where I'm the first person to kick Congress and saying they're not doing anything and Texas can lead. We do need federal support on this because the FTC is trying to enforce COPPA to the best of their ability, but the loophole and the workaround is such that there have been, oh gosh, I don't know how many cases brought under COPPA, but only a handful that have resulted in actual settlement or some kind of action brought against companies. But this has been the defining feature of how tech companies get around child safety laws is we don't have actual knowledge. They accepted the terms of service, so we were able to presume they're 13 plus.
All right.
I will say one law, I mean, currently going through Fifth Circuit Court, the App Store Accountability Act, that requires age verification at the App Store level. And the idea behind it was if you are a verified child based on verifying your age, then mom or dad approve or deny apps that you want to download. And the thought process behind that is now that information, that age is shared with the app itself. So they know, they have actual knowledge, this is the age of the child. When that takes full effect, I think you're going to see a sea change in litigation and action brought against tech companies who, back to the question, Representative Tinderhold of retroactivity, decades and decades of violating and just outright bragging about flouting state law.
All right, thanks, guys.
Representative Bowers.
Great. Yes, thank you, Mr. Chairman. And quickly, in the essence of time, I have put my two questions into one so that we can get out of here. What protections are currently exist under Texas law or are safeguards to prevent someone from using commercially available location data, as we've been talking about, to track another person's daily routine, including where they live, work, receive health care, seek social services, or interact with law enforcement? So is there anything in place currently?
Yeah, I can take a first stab at that. So under the Texas Data Privacy Security Act, I mentioned that class of sensitive information, which is a lot of what you were just describing. And if I'm not mistaken, that requires affirmative consent. So tech companies or any of the companies, which is back to the Attorney General's office, this law applies to anyone who conducts business in the state of Texas, collects or engages in the sale of personal information, and is not a small business under the United States Small Business Administration standard. So based on that sensitive information, companies cannot obtain or sell that without my affirmative consent. So that is a strong protection in place that's meant to remedy much of what you outlined. On the data broker front, again, I imagine my colleague from Texas Appleseed can hit more directly on it, but I will say that being the organization I mentioned that collects all that hyper-personalized data that can be used against you, we now require registration with the Secretary of State's office, so we have more transparency into they have to go through the filing process like any other business in the state, so we have a better sense of who they are. I think there's more the state of Texas can and should do on that registry to say, much like the Texas Data Privacy Security Act, I can opt out of those data brokers going into business with me. And extending on our comments, if data is our property, it doesn't matter if somebody violated my property rights to give to a data broker to further violate. A violation is a violation is a violation. So a great foundation, but I think there's more work that can be done next session, and I'd be happy to discuss further offline with you in your office if that's of interest.
Yes, absolutely, and thank you all for seeing it as property rights. Thank you.
Thank you.